First of all, I want to take this opportunity to welcome you to the 2016 AALS Annual Meeting, opening plenary program Lawyers as Professionals and as Citizens. Thank you very much. Thank you. Thank you very much. Thank you. Thank you. Thank you. I have this prepared statement because this is being podcast, so bear with me a little bit. A CLE attendance sheet is located in the rear of the room. If you sign, the AALS will verify your attendance at this program for CLE purposes. Please complete the session survey found on the AALS mobile app. We value your feedback and very much look forward to it. Ladies and gentlemen, my name is Blake Morant. I'm the Dean of the George Washington University Law School and the current President of the Association of American Law Schools. And it's my privilege to welcome you to this particular opening plenary program, one of the first that we've ever had at a session such as this of the Association of American Law Schools. We have an active and very full program for you today. As I was beginning to come in, I noticed that everybody was communing. This is what this meeting is all about. We want you to do that. I also have a number of different recognitions to do today. The list is relatively long, and I have 1 hour, and I have these special guests. And so if I talk too fast, my interpreters will help me out in a very great deal. Okay. First of all, I want to do something that I think is very much appropriate. We're doing something this year at the meeting that we haven't done really in a concentrated way before, and that is that we've invited a number of individuals from the bench and bar to be with us at the meeting. As you see from the title of our program for this entire event, we are showing not only that lawyers are professionals, but as academics, we have great synergy with those who are in the profession. So many of them will be with us throughout the course of our annual meeting, and some are with us today. I'd like to take this opportunity, if you would, to just turn around to your neighbors, greet them, and if it's a member of the bar, please tell them that you're very happy to have them here. Thank you very much. Thank you very much. I'm so glad. This is one of the things that I've enjoyed so much about being a part of this organization, that the fellowship will continue. And I want you to keep that spirit throughout the next few days that we have this annual meeting. Ladies and gentlemen, during my year as president, I've had the esteemed pleasure of working with a very talented group of individuals who've been on the executive committee for the Association of American Law Schools. They have represented you well. They have conducted the business of this association well, and they have helped enormously in putting together what I consider to be one of the star annual meetings that we've had. I would like for all of the members of the executive committee who are here to stand to be recognized. Also, I'd like to recognize several members of the executive committee who are going to be rolling off this year. And I would like to first of all mention an individual whom I've had a great degree of respect for a very, very long time. Daniel B. Rodriguez, who's Northwestern University Pritzker School of Law, and Guy Charles of Duke University School of Law, and Wendy Perdue of the University of Richmond School of Law. All three of these individuals have served for the last 3 years. As you know, Dan Rodriguez was my predecessor as president. Ladies and gentlemen, these individuals have made an indelible mark on this association and have left a legacy that we're going to continue forward as the association moves in its very important agenda. I would like for them to stand and be recognized for their extraordinary work on the executive committee. You know, it takes a great deal of work to put these programs together. We have a great staff and literally hundreds of volunteers who help us to put on the annual meeting every year. This year, for the first time ever, we have a AALS program committee, which was chaired so ably by Dean Ben Barros of the University of Toledo, and to the task force on professional development under the leadership of Professor Susan Carl of the American University Washington College of Law, which has launched its first ever arc of career programs. I would also like to thank the chairs of the 100 sections of the AALS whose hard work has made it possible for these programs to flourish at this meeting. I will now ask all of the chairs and the members of both the 2016 Program Committee and the Task Force on Professional Development to please stand and be recognized. Good teaching matters to us all, to our students and to their future clients. Recognition of excellence in teaching is one of the ways we reinforce the most important academic values. The teachers who were recognized by their law schools during the 2015-2016 year for outstanding teaching are listed in the opening program's plenary section program. With the teachers of the year who are in attendance, please rise. We're privileged to acknowledge your excellence in this mighty craft. I hope you'll take the time to review the names of those recognized who have done so well in the craft of teaching, which has great synergy with everything we do as academics. I joined the Legal Academy about, and this is really very poignant for me, and when I joined the Legal Academy about, so many years ago, and during those times I've had the opportunity to see so many positive impacts that have happened with regard to quality teaching, scholarship, and service, and how legal education changes the lives and improves so many people's existences in our community today. Legal education requires our collective dedication and imagination. Despite questions about its value, the need for quality legal education has never been more distinct. In the year that I've been president, I've had the opportunity to speak at many different venues, both within law schools themselves, higher educational institutions, overseas and here. We live in a globalized society, really a globalized community that now crosses borders. And with all of that various connection, there's never been a more distinct need for individuals who are qualified professionals, who crave diversity, who understand the need for critical thinking, for problem solving, all of the things that we do in the Legal Academy. But we are challenged, and we know that we've had those challenges, but at the same time, this is a time of innovation. Challenge brings about innovation, and that is the thing that has really excited me all of this year, and hopefully will keep us buoyed, because this is part of the continuing evolution of American legal education. Of course, it's challenging, but it's never been more exciting. And I am gratified by all of the work I see done by our colleagues and how we have been able to progress during these very difficult times. Notice that our title today has to do with lawyers, the academy, and professionalism. Three things that I think have always been synergistic but have taken on greater hold in recent days, and certainly in recent years. Our speakers today are Benjamin W. Heineman, Jr., former Senior Vice President for Law and Public Affairs, General Electric, and Professor David B. Wilkins, Harvard Law School, whose detailed biographies you can find in the programs that you have. Professors Heineman and Wilkins are co-authors, along with William F. Lee of WilmerHale, of a landmark article, Lawyers as Professionals and Citizens, Key Roles and Responsibilities in the 21st Century. Their essay presents a practical vision of the responsibilities of lawyers as both professionals and as citizens at the beginning of the 21st century. Ben and David, we're so appreciative to you for taking the time out of your busy schedules to be with us today. Colleagues and friends, please join me in welcoming Professors Heineman and Wilkins.
It's a great honor and pleasure to be with you today. The purpose of the essay was to put an emphasis on the imperatives of the lawyer's responsibilities in an age when too much discussion is about economics, and obviously there is economic turbulence, but we need to focus again, I think, in all parts of the profession on our responsibilities and our duties. It also calls, as Blake mentioned, for collaboration between law schools, law firms, and legal departments, something that I think can provide great synergy and great insight in all sorts of directions. Today, I'd just like to talk a little bit about our framework and about one particular role, the General Counsel, who illustrates all the problems and difficulties of discharging these responsibilities. And then David will talk a little bit about the implications of our essay for the law schools. Very simply, we argue that lawyers have three broad roles. Obviously, we're technical experts, expert in law, knowledge, application of law to facts, and so on and so forth. But we are also wise counselors, and that takes us often way beyond what the technicalities of the law are. And many of us turn out to be leaders. And I think that one of the most important things that we can recognize is the broad set of roles that lawyers have other than being in law firms in for-profit, public, and not-for-profit institutions. I think we also need much more training on the counseling role, which is extremely complex, and beyond that, of course, on leadership roles, which, depending on the institutions, are extremely complex. And we argue in this essay that we need, in addition to the core competencies taught at law school, which are critical, are the basis for all of our careers, we also need some greater emphasis on what we call the complementary competencies. We put a lot of emphasis on four responsibilities that all lawyers have. And this is, again, what we're trying to re-emphasize in this particular era. First of all, to our own institution, to our employees, our students, as the case may be, but also to the enlightened self-interest of the institution. There's a lot of discussion about short-termism. Having been in law, government, and business, I can testify that there is lots of short-termism. How can we basically reorient ourselves a little bit to the enlightened self-interest of the institution over the longer time frame? Secondly, to the clients and stakeholders, and the corporation, obviously, to the shareholders, the creditors, the partners, the customers, and the suppliers. What kinds of obligations do we owe them? The third duty is, of course, to the rule of law and to the administration of justice. That's incumbent upon all of us who are part of this profession. And lastly, and of course, most important perhaps, to society, to securing the public goods upon which society depends and which cannot be attained through the market alone. Each one of these duties requires very broad vision and, in turn, broad knowledge and skills. The four responsibilities require, as I indicated, complementary competencies. I'm not going to read what's on the chart. Again, you all have, I hope, online copies of this essay. It's long, but you might want to at least skim through it. But there are a lot of things, I think, that we don't necessarily emphasize either in law school or in law firms or in law departments that are very important. How do we ask ought questions about what should be in the future? And how do we generate robust options and balanced recommendations? How do we develop literacy in the social and natural sciences so that lawyers in their jobs can ask hard questions of experts and have some sense of when there are bogus claims and very certain claims, and then what do we do when there's division and debate within these various disciplines? How do we assess risk? Not just be risk averse, but basically figure out how to take risk. One of the most important subjects, especially given the events of the last 15 years. How do we build organizations? How do we have the vision, the values, to know how to institute the systems and motivate the people? How do we understand, how do we make rules realities? Do we spend enough time talking about execution and implementation? How do we understand the interplay between policy and politics? We live in a democratic society. Everything we do, maybe with the exception of the judiciary, although there could be a good debate about that, involves politics to some degree. That's the nature of a democratic society. And yet we have a very dysfunctional political system, in my judgment. How do we connect that with good policy? Critical set of questions. How do we have global brains and cultural sensitivity? And lastly, how do we define problems? I think it's sort of self-evident that if we don't define the problem right, we're not going to solve it. And yet, defining the problem correctly is one of the great failings. If we look at all the failures of government or business of the last 40 years, you could say that the real problem was that the problem was defined wrong or incorrectly. It wasn't defined properly. So how do we train people to define the problem that they're solving correctly? Another part of the framework is two aspirational roles for lawyers. The first is the lawyer statesperson. Simply stated, that means that the first question we all ask is it legal? Of course we ask that question. But the last question we ask in our institutional roles is it right? And right combines a combination of prudential and moral factors in very complex contexts. It's multifactorial and it's very contextual. There is no cookie cutter. There is no Rawlsian answer to every problem. And it's sort of balancing the enlightened self-interest of the institution with the rights of and the duties to other people or other institutions. And it views all problems through the screens of performance and law and ethics and risk. When you're asking, is it right, you want to look at all those factors at a minimum in trying to determine whether it's the right course of action. The second important aspirational role is what I call the partner guardian. To be effective, you have to be the partner in a big institution to the leader, whether it's the CEO or the president or the cabinet secretary or the head of the foundation, whatever the case may be. But at the end of the day, as professionals and citizens, you have to be the guardian of the institution. And of course, in many cases, the lawyer technically represents the institution and not the individual. And yet, there's often a tension between them. So how can we resolve this tension so that we are not inveterate naysayers or inveterate yay-sayers? Naysayers, you don't get to come into the room. Naysayers, yay-sayers, you go to jail. So you've got to find the balance between these two roles. Let me just end briefly by talking about an example of lawyer as professional and citizen, the general counsel, a subject I know a little bit about. I spent nearly 20 years as the general counsel of one of the biggest global companies, GE. But these jobs are critically important, and they're really quite fascinating when you think about it from the point of view of law schools and law firms who are training people to go there, and companies who are, of course, have people who are counsels in their divisions or general counsels and then send people off to other jobs. But look at, we have the White House counsel, the general counsel of Treasury, State, DOD. These are vital jobs, very important jobs in the nonprofit sector. I just spoke to the university chief legal officers, fascinating group with fascinating set of problems and a wonderful casebook written by Professor Areen. Foundations, and then of course there are general counsels in the for-profit sector, whether they're publicly held or privately held, corporations and partnerships. And today let me just talk very briefly about the multinational corporation. This is very hard to read, but I think it's very important. I have argued for some time, and I tried to argue in my career, that the goals of the corporation are the fusion of high performance with high integrity. Yes, of course, we want high performance, strong economic growth, good goods and services, durable benefits to the shareholders and other stakeholders, and balancing risk-taking and risk management. But that all must be done with integrity. And integrity, in a nutshell, is law, ethics, and values. It's basically robust adherence to the spirit and letter of the formal rules, and that can be legal and financial. It is the voluntary adoption of ethical standards that are uniform across the globe, that are actions taken beyond what the law requires voluntarily by the corporation or by another institution. And in the corporate setting, it also means, in my judgment, public policy that balances the public and private interests. Too often, corporations simply want to advance the quarterly profits or their bottom line. They have a responsibility to think broadly about public policy and the public interest as well as the private interest. And finally, we have to have an employee commitment to the core values of honesty, candor, fairness, reliability, and trustworthiness. That makes a functional, highly productive institution. If you don't have those, you have backbiting and turf fighting. But you cannot have those values unless you've got the first two elements of integrity, adherence to the formal rules and the adoption of ethics. There's been an inside counsel revolution in the last 25 years, and I was very fortunate to be a part of it. Inside the company, and I mention this only because this just illustrates the complexity of these roles, that inside the company, the general counsel has become the primary counselor to the CEO and to the board. No longer is it the senior partner in the law firm, it's the general counsel. I sat 10 feet away from two very difficult and controversial but talented CEOs, Jack Welch and Jeff Immelt of GE. You're a member of the senior management team, and you're doing both law and business. You are there to give advice on business decisions, not just on legal issues, and you of course have to know which role you're playing and whether what you're saying is covered or not by the privilege. There's a dramatic change in the skill, experience, and compensation. Former attorneys general, former deputy attorney generals, former head of the White House counsel's office, former heads of critical departments of the SEC, former senior partners in law firms have now become general counsels. And from the point of view of the board, they're now comparable in importance to the chief financial officer. Also, outside the company, there's been a revolution, that there's been a shift in power from the outside law firms to the inside legal departments. The inside legal departments, at least when peopled by talented lawyers, basically have control over the matters, they have control over money, and they've become public figures. They speak in public forums a great deal now. They used to be hidden in the back room. They negotiate, their public figures, and have a very important public role in representing the company. Let me just end by giving 4 examples, going back to the 4 duties of the kinds of issues that we have to worry about. I cannot talk in any depth about them, but I just want to give you a flavor of them. Inside the corporation, the most important thing we have to do is create a culture of integrity. Anthro 101 would tell you that culture is shared principles and practices, how people think, feel, and behave. That involves a variety of things that need to be done. You have to articulate the aspirations, you have to educate and train, you have to discipline people when they do bad things, you have to create systems and processes and resource them. Extremely complicated. Everyone in this room knows how complicated culture is. How do you create a culture in a big institution? I work for a company that had 320,000 employees in 120 countries. 320,000 employees in 120 countries. It was bigger than the city of Orlando or the city of Buffalo. Not a small task. Secondly, with respect to stakeholders, how do we deal with global supply chains? One of the great issues in globalization today. What kind of labor standards do we apply at third-party suppliers? Nothing in law requires that we do this. So it's an ethical choice. What do we do? What do we do about child labor, about wages and conditions? What do we do with respect to those kinds of issues? What do we do with respect to environmental health and safety? What do we do about the quality of the products? A critically important thing. We have a process called deverticalization. Deverticalization, where no longer does the company make everything from start to end, but they still have a responsibility for making sure it's of the highest quality. Very tricky question. And what do we do about those workers who are laid off as a result of globalization? What kind of responsibility do we have to them in terms of severance, training, and outplacement? Third issue, society and public goods, energy and environment. How can companies create both public policy and technology to address climate change or to reduce other externalities? Conservation of water, handling waste, conserving energy. Again, long-standing problems, but with great new dimensions. The general counsel is right at the center of all these issues, but they go far beyond law when you're trying to figure out what the company should do. And lastly, the legal system. We have to deal, and I was very involved, I don't have time to talk about it, in the anti-corruption movement, which is one of the great scourges of our global system right now, and indeed is a national security and foreign policy question, because failed states, corrupt states, also spawn terrorism and other kinds of crime. How do we establish rule of law in all these emerging markets? And even in our own country, we all know, and it'll probably be discussed at this meeting, that there's a huge needs gap in terms of getting people proper representation. It's a scandal. It's an utter scandal. We all know that. What are we going to do about it? How can we think systematically about it? And that's a responsibility of all of us. And lastly, how do we inspire young lawyers? All of us, I think, have been very fortunate. We all would say our lives in the law have been terrific. I'm not so sure that a lot of young people, and I teach and David teaches, feel that way. And they don't feel that way necessarily after their first 3 or 4 years of experience. So how do we basically inspire them again with this broader vision that I think really is very traditional, even though we're trying to re-emphasize it in this century? How do we inspire young people to do this? And one of the things that we try to argue in the paper is that there should be greater collaboration in the transition from the first year of law school, maybe from college, through law school, through the early years of their practice, so that they really do have a capacious vision of what a lawyer could do. And that requires, I think, cooperation between law firms, law departments, and law schools. And with that, I'm going to turn it over to David Wilkins. Thank you very much.
So I think you can see already the value of what we're trying to do. I had the great privilege of working with Ben Heineman. If Bill Lee were here and had a chance to speak, you would have been equally impressed with him. Ben and I teach a course together called Challenges of a General Counsel, in which we try to address some of the amazing things that he just talked about. And Bill and I teach together in Harvard Law School's problem-solving workshop, in which each of us are one of the 7 teachers teaching in the course. And the collaboration with these incredible practitioners with their experience in the real world has been amazing. And if nothing else you take away from this session, that is one of the main points I hope that you will take with you. I want to say a few words about how all this relates to the job most of us have in this room, which is being involved in legal education. And it's a complicated transition to make because legal education is an incredibly complicated context to talk about. And that's because there is no such thing as a law school or legal education. There isn't actually a one-size-fits-all understanding of what law schools are supposed to do. And the problem, one big problem, is that we've been forced into thinking of it as if it is one-size-fits-all. That has something to do with regulation. And so one of the people that we've engaged on this process, or one of the entities, is the American Bar Association in trying to think about how we ought to think about regulating for a profession that is increasingly diverse and, quite frankly, is segmented in important ways. But some of it is also cultural, a feeling that if we don't look exactly the same, that somehow we're not as good. And I think these are questions that as law professors and as deans and as people engaged in legal education, we need to think seriously about. We tried to address this by being clear about the context we were writing about. The context we were writing about is what you might think of as the ecosystem in which law schools, companies, and important law firms operate. They do constitute an ecosystem, and as Ben just said, it's incredibly important that they think about themselves as being connected. But they are, of course, not the only ecosystem. And many of you teach in law schools that have their own ecosystem in terms of where graduates tend to go, in terms of the communities in which you sit. And part of emphasizing context is to say it's important for us as legal educators to think about the context in which we operate. So when you read our paper, that it's about a particular context, and we try to be very clear about that, but think what is it that is your own context and how that relates to the mission that you have. Having said that, it's also wrong to think of ourselves as living in completely separate and independent worlds. And that's partly because one of the features of the modern legal profession that I spend most of my career studying, and frankly, one of the features of the modern world, is the increasing mobility of people across different kinds of contexts. So I hope many of you are familiar with the After the JD study, the 10-year longitudinal study of lawyer careers, which I spent more than 20 years of my life doing, along with a fantastic team of other professionals across many disciplines. And one of the key findings in studying a random sample of 4,000 lawyers across every law school in every region in the country is how many jobs people have had over the 12 years of the study. Something between 3 and 4. And many people are moving not just within the same part of the profession, but across boundaries like public and private, big firm and small firm, and even across that most impenetrable divide, law and what we charmingly call non-law, as if law is the center and everything else is the periphery. In the study I also did of Harvard Law School graduates, something like 25% of all of our graduates were not practicing law at some point in their career. We need to think about an education system that also addresses that, which then fits with something Ben just emphasized, which is even if you are practicing law, you're doing so much more than practicing law. The boundary between law and politics and economics and sociology and psychology are becoming increasingly blurred. And that is particularly true in a role like the role of general counsel, but if anybody's in family law practice or anybody is in criminal law practice, they know that all of these multiple disciplines are relevant too. So how do we think about what legal education means in this kind of complex world? One more complexity. Law schools don't just do one thing. Of course, the main thing we do is we teach students and try to prepare them for their careers. But we also are responsible for producing knowledge about law and legal institutions and the relationship between law and society. This is why much of the debate over legal education, I think, which has been framed as a kind of fight between theory and practice as if it's a zero-sum game, misses the point. Because law schools have to be about both theory and practice. And in many ways, we need more of both. We need a theory of practice. As practice changes, we need to have a way of understanding that practice. Legal educators can help legal practitioners think about what it is that they're doing and why they're doing it and how they should be doing it. Ben has been a pioneer in this, and I've learned tremendously from him on this. But we also need to test theory in the crucible of practice. That is, to the extent we make ideas, which we should, about how the world should work, we need to be willing and able to test those theories in the crucible of real empirical research, which is why empirical work needs a much higher place in the legal academy. Finally, law schools are a gateway into professional jobs. And we have to be honest about that. Our students come to law school in part because they want employment. And we need to think about what the proper connection is between the law school as an educational institution and as a gateway into professional careers for our students of varying kinds. Let me say just a few words about the first two of these missions. And I'm only going to say a few words because these are very complicated issues. But we talk in the paper about how to think about what we teach our students. And we argue that thinking about teaching is not just one issue, it's really 5 different issues. It's what we teach, how we teach it, when we teach it, and for how long, and who should be teaching it, right? Each of those are complex issues. We argue that for the what question, that at a minimum, we have to address much more directly the profession itself. Law school has often taught a lot about law. It hasn't taught a lot about lawyers or legal careers or the complexity of the kinds of roles that Ben has talked about. I wrote a diatribe many years ago in the Journal of Legal Education saying the professional responsibility of law schools is to study and teach about the profession. And I think it's more true today than ever before as the profession becomes more complex. Moreover, we have to teach about the intersection between law and these other disciplines. Ben talked about complementary competencies. We suggest a few core ideas that every law school ought to think seriously about teaching. One is business literacy. The second is technology and its influence over society and over professional practice. I have a whole research project on disruptive innovation in the market for legal services. The third is institutional design. Most lawyers work in institutional settings, and one of the key roles lawyers play is setting up functioning institutions. How do we do that? Fourth is collaboration across difference. The world is becoming increasingly diverse in every way one can imagine, and collaboration is the key to solving big problems. And yet, typically, when we teach students, if they collaborate on something, we call it cheating. Fifth, we need to think about the ethical dimension. Ethics, as Ben says, are the fundamental key to what we do. Not just is it legal, but is it right? Second, about how do we teach? We need to do much more in the way of creating real-world case studies of the kind that Ben talked about. Each of the examples he actually raised are case studies that we teach in our course together called Challenges of a General Counsel. In the problem-solving workshop I teach with Bill Lee, all the cases that we use are real cases in which we don't start with the legal category, we start with the problem. Typically when we teach contracts, we say it's 10 o'clock in the morning, it's contracts class, therefore everything we're going to talk about is a contract, and we're going to teach contracts by looking at failed contracts that ended up in appellate litigation before famous judges. That's one way to think about a contract. But that's not the way lawyers interact with contracts. They interact with contracts when somebody walks in the door and says, I'm thinking about doing something, and I might need some help, and how do I get that help, and who are the parties, and is it a contract, is it a merger, is it a joint venture? That's the way clients and lawyers interact. That's how we need to teach our students, and that's what real case studies can do. In terms of the win, one of the most controversial issues in legal education today, of course, is the length of law schools. And again, my sense of the debate over the third year, and whether we should have it or not have it, is that it mostly misses the point. I think law school is both way too long for many things that lawyers do, and way too short for many of the things that we need lawyers to do. So the idea that you need 4 years of college, 3 years of legal education, a bar exam, character and fitness review, in order to do many of the basic tasks that people need from lawyers and the law is crazy. And we need to think seriously about deregulation. And there's some interesting moves, as many of you may know, already underway. Triple LTs in the state of Washington, thinking about online, do-it-yourself, LegalZoom. We need to endorse and work hard on thinking about what things don't require the full training. Not that they don't require any training. Maybe it's a 6-month course. Maybe it's a year course. Maybe it's an undergraduate concentration. We need to think seriously about that. On the other hand, to tackle the complex things that Ben has talked about, we need lawyers to have training in much more than simply what we teach them even in 3 years of law school. Here's where we think the third year can come in. The idea of having the third year that simply just repeats the first and second year, roughly speaking, doesn't seem very helpful, and there's a reason why when I studied third-year law students, it was hard to study them because it was hard to find them in class. That should be an indication of what we're doing. On the other hand, it's crazy that it takes 4 years to get a joint JD MBA or a joint JD Master's in Public Policy or a joint JD Master's in Computer Science. Why not do those in 3 years? Why not have externships that are supervised by law schools, but where students work either for credit or pay or for reduction in tuition? We could do creative things with the third year if we put our minds to it. On the other hand, the idea that you could teach everything, even in 4 years, that people need to know throughout their careers is crazy. The world is changing way too rapidly. So many things you can't teach about until people have experienced them. We need to have an understanding of lifelong learning and extending the law schools out into the profession. I've tried to do that at Harvard by starting programs on executive education. I'm looking at one of my best students sitting in one of the front rows here, who was kind enough to come see me here today. But all law schools could think about engaging with their graduates and with others throughout their careers. Harvard Business School, as most of you know, has a huge exec ed program. Right now, Harvard Business School is about 60% focused on MBAs, 40% focused on professionals of all kinds, not just their graduates, in lots of different ways, online, some in residence. Their plan in the next 10 years is to switch that. They will be 40% focused on people right out of school or, relatively young, and 60% on professionals because they think the real learning needs to take place later in their careers. That also suggests who should be teaching law. Yes, it's very important that we have academics who are trained in the teaching of law and in legal research. That is a part of what we need to do to produce the knowledge we need. But we need to teach collaboratively. with practitioners and with others from other disciplines if we're going to provide the well-rounded knowledge that lawyers need. Let me just say then briefly what that means about knowledge production and legal scholarship. As I said, we need scholarship that engages practice and is informed by practice. That means that law professors have to understand themselves as a part of that connected ecosystem that is the legal profession and the role of lawyers in society. Because as I said, many don't just practice law. One of the perhaps most controversial things we say in the paper is that as much as it's important for law professors to be connected to the academic profession, it's more important that they consider themselves to be a part of this connected ecosystem that's around lawyers and the role of law in society. That has important implications for what we do and how we select people to become law professors and how we evaluate the work we do. In some ways, the duty that Ben put first on his list is the one that we spend the least time thinking about as law professors, which is what are our obligations to the institution itself? You know, other than grading our exams and showing up for faculty meetings every once in a while, law professors like to think of themselves as totally autonomous beings. But that actually is a disservice to the critical role that we have to play in building institutions, particularly in this complex time. And those of you who are deans in this room understand this, but it's hard to get professors to understand that this is a critical part of their role as well. Our goal in writing this paper is to try to start this conversation, not to finish it. Although our paper is a trim 85 single-space pages, we do not actually think that we've answered all these questions. We've invited commentators to talk, to criticize, to give their thoughts about what we do. And Professor Areen and many others have been kind enough to give us their thoughts. We invite all of you to do so as well. You can find our paper on the Center on the Legal Profession website, and there's a section for comments, short or long. I hope that we can have this conversation. Eventually, I think we'll try to publish this all as some kind of a book so that we can continue that conversation. We had a conference at Harvard Law School in which we invited judges and practitioners to come and tell us what they think, and we hope that we will be able to continue this discussion. Because as Ben said, this is a critical time for the legal profession. Yes, we cannot ignore that we live in an increasingly complex market. This is one of those boundaries that is blurred between law and business. When Judy and I started, we went to endless conferences called Law, is it a profession or a business? You know, it was probably a dumb question then, but we don't even ask that question today because of course it's both. It's a complex, increasingly global, sophisticated business, whether it's at the solo practitioner level or at the highest corporate level, but it also has to be a profession that guards a set of sacred professional ideals. This leads to what I call sometimes the paradox of professional distinctiveness. I'm hoping people will put it on bumper stickers, but I haven't seen it yet. In order to be successful, lawyers have to understand themselves in the way that other market actors do, as operating in a complex, very competitive profession. And those of you who teach solo and small firm practitioners know that this is true, even as those who are in the largest law firms know. But if lawyers are just the same as other market actors, then why in the world should anybody go through all the trouble it takes to become a lawyer? Why should lawyers have any form of professional independence and self-regulation? There's something distinctive about being a lawyer that we ought to embrace and hold on to, and that distinctiveness are the norms of public service, of service to clients, of fiduciary obligations, of commitment to the rule of law, to our highest ideals that Ben spoke about. We hope that we've made some modest contribution to thinking about what those ideals might mean in the context of the world that we think about today. But we know there's much more thinking to do, which is why, of course, we're so honored to be here with you. Thank you very much.
Ben and David, I know I speak for our entire assemblage when I say thank you so much for that wonderful presentation. It spoke to me and spoke to so many of us in a way that really addresses many of the issues that we've been talking about in contemporary legal education. As I was sitting there hearing the two of them, I had this panoply of questions, and I saw people on the edge of their seats who would love to be able to do this. This is one of the frustrations of the way we organize this, because we don't have enough time to have oral questions today. I did query the two of them. There are two things that you can do. One, they are very welcoming of comments, both in their comments that they've made today, as well as the materials that they've talked about in terms of the article and the essay that they wrote and the book that they have. Please, please feel free to contact them and give those comments. They're very earnest about that. If you like their work, tell them. If you don't like their work, be very judicious. But at the same time, just contact them. This is an issue that I heard about constantly as I've been president and talking about the law, the legal profession, how we can be more adaptable in the 21st century. You address that in a very probative way. We look forward to continuing that conversation. I certainly do, and I know my colleagues join in that. I also want to mention to you that Ben has a book coming out this March, and Ben, you correct me if I'm wrong, I think the title is The Inside Counsel Revolution, that continues a lot of the points that he was talking about today. Please stay tuned to that book. This is a conversation that we will continue, and I'm very grateful to you for getting our conference off to a rousing start. Let's give them another hand, ladies and gentlemen. And I've invited them both to stay for as many sessions as they possibly can. Please be nice to them so that they will stay. Ladies and gentlemen, at this point, before we adjourn, in 2006, the Association of American Law Schools established the AALS Award for Lifetime Service to Legal Education and the Law, an award that's presented only every 3 years. The award was designed to recognize lifetime service to the legal education by an outstanding faculty member or retired faculty member at a AALS member school. The 2006 award was presented to Norman Dorson, New York University School of Law. The 2009 award was presented to the Honorable Guido Calabresi, United States Court of Appeals for the Second Circuit. And the 2012 award was presented to the late Derek Bell, New York University School of Law. Today, we honor Professor Herma Hill Kay, University of California, Berkeley School of Law, with the 2015 Award for Lifetime Service to Legal Education and to the Law. I would like to introduce and invite to the podium Professor Patricia Kane of Santa Clara Law School to say a few words about Herma Hill Kay. Patricia?
What an honor it is to say something about Herma Hill Kay. I mean, everything you've talked about, leadership, integrity, that is Herma. She is absolutely one of the leading lights in legal education. I have written a full citation, thanks to Judy Areen, who asked me to write something for her, and it's in your program. So I'm not going to repeat all of that, but I will say a couple of things. Many of you have been inspired by Herma throughout. I mean, she's been the leader of this association, the ALI, several sections of the ABA. She's been a leader in legal education throughout her life. In 1977, Time magazine named Professor Kay as one of 10 law professors who were likely to shape the future. And she did. She shaped the future by being a law professor, a dean, changing the law of divorce. I mean, she is solely, well, not solely, but primarily responsible for introducing no-fault divorce, first in California. But I do think Herma's most important contribution, both to the legal academy and to the world, can be found in the growing number of law professors, lawyers, judges, etc., that Kay has mentored over the years. Her students love her ex-students love her colleagues honor the support she has offered them. They all speak with affection and awe about her. One prior student, sitting in the audience right now, Susan Appleton, calls her a rock star. But my favorite is Justice Ginsburg, who collaborated with her early on in sex discrimination law. This is what Ginsburg has to say. Herma Hill Kay, grand human. I can't think of any words better than that. So this is to celebrate Herma Hill Kay, who deserves this award so much. Thank you.